Hello and welcome everyone to our webinar today on cybersecurity for in-house counsel, understanding risks and legal obligations. My name is McKee and I'm a practice leader in LegalVision's commercial and regulatory team. Before we begin today, a couple of quick housekeeping items. You'll receive a recording at the end and the slides by email at the end of today's webinar. There's a Q&A box where you can submit your questions. I encourage you to submit as many as you wish. That's always a very useful part of these webinars. And after the webinar, we'll be sending through a short survey. It'd be really appreciated if you could fill that out. The other thing I just wanted to flag is that you are all eligible for a free consultation with LegalVision to learn how we can help your in-house team manage your high volume of business as usual legal needs. So what you can do is you can provide your details at the end of the webinar in the survey that we sent through to you. I'll run through what we're going to talk about today and then we'll get straight into it. So I'm going to be discussing what cybersecurity is and having a look at the Australian cybersecurity landscape. I'll then run through strategies for cyber incident response and also discuss your role as an in-house counsel in a data breach and what you should be doing. So we'll jump straight into it in terms of cybersecurity and what that is. I think it's important that we understand what a cybersecurity incident is and what cybersecurity means. So a cybersecurity incident is any sort of unwanted or unexpected cybersecurity event or series of events that compromises your business or your systems or has a significant probability of compromising your business operations. In terms of cybersecurity, what does that mean? Well, that's the art of protecting your networks, your devices, your systems from any unauthorized access or any sort of criminal behavior where someone is going to make your, business information, confidential information, availability of your information at risk. So in essence, a cybersecurity incident, usually there's some sort of criminal or malicious intent there, and it will pose a serious threat to your business. I'm going to run through a couple of the common types of cyber incidents now, just before we sort of get stuck into today to give a bit of background to what we're talking about. So on the screen here, I've got 4 of the most common types of cyber incidents. First one is hacking. I'm sure we've all heard of hackers and what they do. Essentially, that refers to when there's unauthorized access into your networks, your systems, your devices. Typically, that's used to exploit the information you've got in your networks, your devices. Perhaps once the hacker's in, they will be able to steal information. Perhaps that's credit card details or financial information, passwords. They also might be able to install other software to further their attack. Beneath that, I've got malware infections, I guess somewhat related to hacking. Malware, it's in the name, malicious software. So any type of code or program that's used for a malicious purpose. So essentially, once someone's hacked your systems, they might use malware to steal information, encrypt any data you've got and use that for ransom, or perhaps install any other software without your knowledge. In terms of ransomware attacks, typically what that means is you've got criminal or cyber criminal looking to encrypt your files so that you can no longer access them, and then they'll request a ransom. Often that's in the form of cryptocurrency, and they might request that ransom so that you can get your files back, or they might say, threaten that they're going to sell the information online or make it available online. So there's some sort of threat there. The last form of cybersecurity incident I want to touch on, and arguably one of the most common. I know when I was having a look in 2022 to 2023, the Office of the Australian Information Commissioner said that the most common forms of cybersecurity incidents for businesses were business email compromise and fraud. So essentially that happens when there's some sort of phishing or spear phishing. Criminals would target your organisation or your email address to scam you out of money, essentially, or goods. Often you'll find in the workplace, there might be someone pretending to be a significant person in your business. So I've received them myself, someone will be pretending to be our CEO, Lachlan, asking me to do a favour, hoping that I'll pass over confidential information. Or you might see people pretending to be, in your personal life, to be a friend or colleague. And asking you for different things. So in terms of cybersecurity incidents, they usually happen with little warning, difficult to prepare for. They might catch you off guard, but of course the consequences can be far-reaching and usually require quick and swift response, which is why it's good to be prepared. And in your role as in-house counsel, you're not necessarily expected to understand and be the technical experts, but you do need to be the legal experts and have a solid grasp of what cyber incidents are, how they can manifest, and what the potential impacts they are going to be. And usually when working with cyber incidents, you'll have a team, and I'll run through this a bit later, but you'll want to have teams from different parts of the business, so your IT team, your legal team, and your management team all working together to help manage any sort of cyber incidents. I'm going to touch now on Australia and what sort of legislation we've got in place and what Australia looks like. So according to OAC, which is the Office of the Australian Information Commissioner, in the first half of 2024, we saw the highest number of data breaches that we've ever seen. And so I guess that just shows that these breaches are going to just continue. This includes the MediSecure data breach, which affected approximately 12.9 million Australians, which was the largest data breach we've ever seen since the introduction of the notifiable data breaches scheme. So I think these sorts of figures show that it's super important for your businesses to be prepared and ready to deal with any sort of cyber incident. In terms of the relevant legislation in Australia, we need to look to the APPs, the Australian Privacy Principles. APP 11 is what's most relevant here, and that mandates that entities must take reasonable steps to protect personal information from misuse, interference, loss, unauthorised access, modification, or disclosure. So that's what we're really talking about today, is putting your business in a situation whereby you're taking those reasonable steps to protect all the personal information that your business has. And in addition, of course, by doing so, you also want to protect your confidential information. Quite usefully, the APPs do set out what reasonable steps mean. So there's 7 steps here, and I would suggest that you have a think about after today's webinar whether your business has these 7 steps in place, and if not, having a think about how you can put them in place. So of course you want to have a business that has a strong culture of a security conscious culture, whereby you've got sort of annual training, your staff are aware of different sort of cyber incidents that may occur. You want to make sure you've got internal systems, practices in process, and we'll run through further today how you can do that. Ensuring your IT team, your tech team has adequate security measures in place to prevent any sort of cyber incidents or to monitor for any cyber incidents. When you're engaging any third parties, your cloud storage providers, for example, or any supplier really, you want to make sure you're doing your due diligence and you've got you're engaging people that you're comfortable with, that they've got in place good IT security measures. Of course, this also affects, I guess, the entire information life cycle. So we also need to have a think about, well, when have you had personal information for too long? And is it time to delete and destroy that information so that it's no longer at risk? Of course, other jurisdictions, we've got the GDPR Article 32, which sets out organisations need to have technical and security measures in place. So this isn't uncommon. And if your organisation does need to comply with the GDPR, you'll see that there as well. We also have a couple of new pieces of legislation that have been sort of billed but not yet in force, which I've just got on the next slide here. So we had at the beginning, not the beginning of the year, recently we had the Privacy and Other Legislation Amendment Bill tabled. Essentially, this was discussed for a long time, and I think a question came through on this, and perhaps this bill had less changes than expected, but one of the changes framed there was that they wanted to mandate that organisations have both technical and organisational security measures in place to manage personal information. So technical being your IT team, you've got like technical protections in place, organisational being more of the whole training in place for staff, having the adequate policies in place, having a good culture of cyber hygiene. The other thing we've seen recently come to the table, again, this is just a bill, it's not yet law, was the Intelligence Services and Other Legislation Cybersecurity Bill. So this was only tabled last month. In terms of what's relevant today, I suppose the bill itself looks to encourage the disclosure of ransomware attacks and to have a better sort of flow of information between authorities and businesses. So both these bills are still in their proposal stage, not yet become law, but I think it's important that you keep on top of them. They might change how things operate. The next thing I want to do is I want to run through different sorts of strategies that your business can put in place for cyber incident response. I've got up here on the screen a quote from JFK, the time to repair the roof is when the sun is shining. I think that's quite apt for what we're discussing today. Of course, cyber incidences can come on quite quickly, and what you need to do is make sure that you're prepared, or not necessarily just you, but your business is prepared such that you can respond nice and quickly. So there's lots of different models, I guess, for responding to cyber incidents. I've got one up on the screen from the Australian Cybersecurity Centre and also from the Australian Security Signals Directorate. There's other models you'll see. There's ones from the US, from the NIST, National Institute of Standards and Technology. They're all sort of similar, but it's important that your business has an approach in place for how you're going to handle cyber incidents. So I'll run around the circle, I guess, to talk through the different stages that we've got set out here. The other thing I wanted to flag is that the Australian Cybersecurity Centre, so there's a website, super useful and has a lot of information on there. One of their things they've got is the Essential 8. The Essential 8 is an approach that they suggest in terms of mitigating any sort of cybersecurity incidents. It's quite technical in nature, but something worth your having a look at, and your tech team as well. It goes through things like making sure you've got multi-factor authentication in place, adequate sort of patching exercises. So something I recommend having a look at after today's webinar. With respect to point one, the first stage is preparation. Of course, that goes without saying. So your business should have a cyber incident response team in place that's ready to go if any cyber incident presents itself. Usually this is made up of people from multiple teams. You might have yourself as a legal counsel, then you also have people from your IT team and perhaps people from management as well. You should have action plans and templates in place for how you're going to deal with a cyber incident. So that includes a detailed data breach response plan, having in place a document retention policy, how long you retain documents for and when you delete them. You should have regular staff training in place, should back up your systems such that if there is any sort of cyber incident, you can't access data, your business can continue operating. You should have regular security testing in place. So your IT team should be sort of monitoring and logging any incidents. Your role here really is to ensure that the business has these elements in place and these things are legally sound, such that if an incident occurs, the business is in a good position to mitigate any risks. In terms of step number two, this would be detect, investigate, analyze, activate. So essentially, this phase is about spotting problems early. Your IT team should have systems in place to monitor any sort of incidents continuously. They should be looking for unusual activities. And if an incident does arise, they need to confirm it, classify it, work out what the actual incident was. And if your cybersecurity team needs to be called upon, then they should be able to activate those response teams. So essentially, your role in phase two is to understand how your business detects threats and make sure you're ready to advise on any legal implications. Phase three is about containing any cybersecurity incident. You want to mitigate any harm that can be caused to individuals. You want to make sure that records are kept of what actually happened, that they're not deleted, and you want to fix that issue as soon as possible. So In terms of your role here, this is where things get a little bit more, I suppose, legal, in that you'll need to advise on the legal aspects of any evidence collection and, most importantly, reporting obligations, which I'm going to go through in a minute. But sometimes you'll have reporting obligations to OAC as well as individuals. Phase 4 is recovery and report. This involves getting systems back to normal, get the business back on track and operating as normal. Preparing any sort of incident reports, making sure there's a log there. You should be reviewing these reports for legal compliance and any issues there. And then, of course, at the end, phase 5, you want to be making sure that after the incident, the business has reviewed what happened, updated any systems, plans, processes, things that weren't working, or perhaps a reason why the issue arose in the first place, and keep those records for future reference. And then in terms of your role, you want to make sure that any lessons learned are incorporated and documented into your business's policies. I read a stat the other day from the ICO, which is the UK's Information Commissioner Office, and that said that they'd done a study and it found that organisations with a well-prepared incident response team and plan typically identify breaches on average 54 days faster than other businesses and save significant amounts of money. So I think that goes far in sort of saying that it's really important to be prepared and to be continuously monitoring for any issues. It will save the business, its reputation, how it can operate, and lots of money as well. On the next slide, I've put together a list of things that your business should have in place. So consider this a bit of a checklist and have a think about whether or not you've got these in place. You want to make sure your business has that cyber incident response team. You want to make sure you've got a cybersecurity manual or policy, basically a policy written up by your IT team and approved by everyone else that sets out what your security measures are and how the business goes about ensuring they're in place and monitoring that. You want to make sure you've got a data breach response plan and a data retention policy. You should have regular staff training. So this includes, I guess you want your staff to be aware of what a cybersecurity incident looks like, when they should raise the alarm bells. You want them to be aware of any sort of phishing or scam emails and keep them alert, essentially. It's also a good idea to, and this is probably quite relevant to your role, is when you're bringing on board new suppliers, you want to make sure you're reviewing those contracts to make sure that there's adequate promises, warranties, protections with respect to how privacy and confidential information is going to be handled. And then similarly, you want to be doing your due diligence on those businesses to make sure you're comfortable and confident with how they're going to handle that data. You should also consider using privacy impact assessments for new projects. So basically that would be any sort of a systematic review or assessment of what you're planning to do and having a think about the privacy implications of that new project you're planning. And lastly, I've got at the bottom a culture of security by design and good cyber hygiene. Essentially, this is a term that's thrown around a lot these days, security by design or privacy by design. Anytime your business is coming up with a new product, a new solution, putting together a new app, for example, you want to make sure that you're thinking about privacy and cybersecurity as you're developing this and designing this, as opposed to an afterthought afterwards when you realise that there is a bunch of issues with what it is that you've produced. What I'm going to go through next is I'll sort of really delve into your role in a data breach and what your notification requirements are. So I've set out here 5 action steps that you can follow if there's a data breach, basically to help you with what you should do and when you need to notify either individuals or the OAIC. In 2018, Australia introduced the Notifiable Data Breaches Scheme. So this is a scheme that where if an eligible data breach occurs, you need to report that. So an eligible data breach is a data breach, and a data breach, going back to that previous definition at APP11, is unauthorised use of or loss, disclosure of personal information that a reasonable person would consider is likely to result in serious harm to any of the individuals to whom the information relates, and where you've been unable to prevent the likely risk of harm with any remedial action. So we'll go straight into the first point I've got here on containment. So essentially, as I sort of flagged before, the first thing, as soon as the alarm bells are rung and there's a cyber incident in place, you should take appropriate steps to reduce the potential harm to any affected individuals. So if you are in a position where you can really mitigate any of these risks, it might put your business in a better position whereby you don't need to notify OAC or any individuals. So make sure you preserve any of that evidence. I've got up here an example which is quite pertinent, I think, and every business can probably relate to this. So you've got an employee, staff member, they've clicked on a suspicious link in an email, which led to unusual activity on their computer and potentially unauthorized access to your company's database. Once you've investigated it, your IT team discovers that malware is actively attempting to spread from the employee's computer to other network resources and try to obtain sensitive data from the compromised database. So if a situation like this arises, in terms of containment phase, your team should be looking to shut down the compromised database to prevent any further unauthorized access. You want to reset the login details and passwords of the affected database and any potentially compromised user accounts. And also, of course, you want to quarantine the employee's device for further investigation. So different containment techniques will be relevant depending on what the issue is. The important thing is you want to really mitigate the risk of that spreading any further. The next step in terms of your action items would be to assess the risk. So, I mean, number one, you need to assess, is this a data breach or is it not a data breach? So going back to that definition of, as I said, being unauthorized use or loss of personal information. There's no data breach, you're not going to be required to make any sort of notifications. If there is a data breach though, then you're going to need to decide whether or not it's reportable under the notifiable data breaches scheme. So when you're if it is a data breach and when you are discussing within the team whether or not it's reportable, the first set of things you should do is have a look at the who, what, where, when. So who caused the data breach, who's got access to the information, whose information was subject to the data breach. So was it thousands of clients or was it just one person? What was that information? Was it particularly sensitive? So was it, health information, for example? What have you done to contain the data breach and what sort of harm might result as a result of this? So would that be financial, physical, psychological, emotional? You also want to have a think about when it occurred. So did it just occur for one day and last one day, or did it last for a period of 50 days before anyone picked this up? And I guess where as well. So was that in Australia or was it overseas? And what were there any, was the information that was targeted encrypted, or was there any technical measures in place to mitigate any risk? So on the next slide, I've got action point 3, which is where you need to determine if notification is required. So in short, you need to assess the likelihood of serious harm to any affected individual. You need to assess whether a reasonable person, so that's a person in your business's position, not a person that was affected by the breach, whether that reasonable person would consider that access to or disclosure of the information would be likely. And we've got I would have said that means more probable than not, rather than just possible, to result in serious harm to any of the individuals to who the information relates. Serious harm isn't defined by the Privacy Act. However, in the context of a data breach, basically the OAC has given us information and guidance that serious harm may include identity theft. So that could include where people, it could affect your finances, your credit report, any sort of financial loss through fraud, where there's a likely risk of physical harm. So that could include abuse by an ex-partner, any serious psychological harm, or any serious harm to an individual's reputation. So the sorts of things you'll be having regard to here is what that information was. So was it sensitive? Whether or not it was protected by any security measures, who's obtained it, was it criminals, the general public, competitors, whether your information was encrypted or if people actually had access to it, and what the nature of that harm is going to be. You should also have a think about whether you have any contractual obligations. Have you promised a third party in a contract that you're going to notify them if there's an issue, regardless of whether or not it's notifiable under the scheme? So in terms of notification, which is action step 4, if a data breach is an eligible data breach, you need to consider 2 types of notification: OAC notification, notification to individuals. Now, in terms of notification to individuals, that is required when a reasonable person would conclude that the data breach is likely to cause serious harm to any individual whose information is affected by the data breach. In terms of timing, at the moment, you've got 30 days to report this to OAC. Obviously, overseas, when we look at the GDPR, for example, there's 72 hours. That's not changed in Australia, but it could in the future. I've got, and I'm just conscious of time here, a couple of examples on the next few slides, which you feel free to run through after the today's webinar, but I might just touch on the first one, 2 perhaps. Basically, these examples run through what a business should do in terms of those action steps when a data breach occurs. So first example, a software development company becomes aware that an unauthorized party has accessed its database, which includes names, email addresses, phone numbers of customers. Internal investigation reveals that the login credentials were compromised after they were inadvertently opened with a malicious email attachment. Shortly after the breach, some affected customers report receiving suspicious emails requesting their financial information. The company determines that the breach has a high likelihood of resulting in fraud or identity theft. So we're looking at what sort of harm could happen there, potentially causing serious financial harm. So they notify OAC and they notify the relevant individuals. I might go to example 3, and you can read example 2 in your own time. In terms of example 3, this is an example of where notification is not required. So in this situation, we had an insurance provider whereby they realised through a security audit by a third party that there was unauthorised access to some of their data, but they couldn't find any evidence that the information was misused or offered for sale online, and it was encrypted. So they felt that the unlikely that would result in any sort of harm, and so that was not reported. In terms of action 5, we touched on this before, but the last thing to do is obviously to record what's happened, review what's happened to see how it could have been handled better, and address any weaknesses. So that's in your systems as well as your organisational measures and what you can do better next time. I think we'll sort of wrap up there. I think the digital landscape in Australia and the world really continues to evolve rapidly. We've got AI, machine learning, the blockchain, Internet of Things, lots and lots of changes happening, which all bring its own set of risks, regulatory considerations, which the law's always trying to catch up with. So I think moving forward, it's super important for you to stay on top of any cybersecurity trends, engage in that ongoing training, foster a culture of security awareness within your organisations. And if you do that, then you're going to be better equipped to handle any sort of issues that arise. So this concludes the main part of today's webinar. You might find our publication useful that's on the slide here. You'll also get a copy of these slides after the webinar that you can use that QR code. You might also be interested in our upcoming event, which is on anti-money laundering regulations, key insights for in-house counsel. I'd also like, if there's any questions, pop them all through, have a think about what you want to ask. I'll run through those questions in a moment. While you're doing that, I just quickly run through a little bit about LegalVision's desk extension. So having spoken to hundreds of C-suite and in-house counsel, we understand at LegalVision that in-house lawyers are increasingly being pulled in many directions, required to put on many different hats, input on business critical strategic matters, the executive level, manage a high volume of business as usual matters. And of course, this is generally all with a tight budget and an even tighter labour market. So under a desk extension, LegalVision can assist you with all of your business as usual legal needs. which allows you to cost effectively increase the bench depth and capability of your team so that you can prioritize the business critical matters that matter to you. Our desk extension lawyers invest upfront in understanding what's important to your business and work as an extension to your team or an extension of your in-house legal function. You might also be interested in our privacy compliance solution. Through this solution, we help audit your privacy practices, provide practical recommendations, do staff training, and assist with all of your privacy needs. So if you have any questions about this or you want to hear more about these two options, please feel free to put your details into the survey at the end of today's webinar. So I'm going to answer a bunch of questions that have come through, and thank you so much for sending them through. If there's further questions, then by all means, send them through right now and I'll do my best to answer them. I had one question come through prior to today's webinar, actually, on sign up. So that first question was, do the new Australian laws bring us closer in alignment with the GDPR or further away? A very good question. I think that touches on what I spoke briefly about at the beginning of today's webinar. So we had a new bill come in place for updating Australia's privacy legislation. To be honest, not a lot of changes were made in that bill compared to what a lot of us were expecting. They've told us that there's going to be different tranches of changes, so perhaps there'll be further amendments coming. In terms of the current proposed changes, so that they're not yet law, but the current proposed changes, I think, as I mentioned, in terms of APP 11, there's talks of that mentioning technical and organisational measures. I don't know if that in practice is going to change a lot. We already have that list of reasonable grounds that they're sort of require. The other key thing, I suppose, when thinking about the GDPR really is that, and I'm sure many of you are aware of this, that under the GDPR, Australia is not considered an adequate jurisdiction to transfer personal information to, which is why often, especially if any of you are SaaS providers or data processors, you have to complete those modules in any data protection or DPA. And so one of the reasons that Australia is not considered an adequate jurisdiction is we have the small business exemption. So a lot of small businesses in Australia don't need to comply with the Australian privacy principles. When I last looked, that was over 90% of businesses. And so as a result of that, I don't think it's really bringing us in alignment with the GDPR. They're still going to, unless that is a change that's made, I can't see us being in a world where they think that the Australian privacy laws are adequate, because at the moment, a large amount of businesses don't need to comply with the privacy laws. The next question I had come through is, what is the best way for an in-house counsel to become knowledgeable on cybersecurity risks? I think in terms of cybersecurity risks, the best things you can do is sign up to Office of the Australian Information Commissioner mailing list. So I'm part of that mailing list. They let you know whenever there's any sort of updates and guidance or any main issues. For example, a few weeks ago, they released a lot of guidance on AI. So both from the perspective of when you are running a business that has AI as its primary, product, as well as a business using AI internally. So they released that. The other mailing list I'd sign up to is the Australian Cybersecurity Centre. That's a good idea. And then, of course, there's lots of forums, Twitter, different sort of meeting groups, but they're sort of definitely the most common ways I stay on top of all of that. I've got the first question here. Are there small business exemptions and can you go through them? So I can. The small business exemption in Australia is basically, the first part is if your business turnover is less than $3 million, then you will not need to comply with the APPs. Of course, there's exceptions to that. So some businesses, even if they turn over less than that, will need to comply with that. The main one there is if someone's providing a health service, they will probably need to comply with that. Other sorts of businesses that might need to is if they're trading in personal information. So if you've got you sell databases, for example, or big lists of information, you might need to comply. The other one that comes up a fair bit is if you provide services to the Commonwealth government, then you'll need to comply with the Australian privacy principles. So we'll keep you up to date on what happens there in terms of the changes in laws, because if that goes, then you'll need to comply with the APPs. The other thing I would say is that even if you don't need to comply with the Australian privacy principles because of that small business exemption, if you are entering into contracts with clients or any suppliers, they might make you promise that you do comply with those obligations. So if you've contractually promised to do that, then you will need to comply with that. The next question I've got here is, we have a small company with only 7 employees. We outsource IT managed services, so mainly an IT help desk. Many of the suggestions today are targeted to large organisations with established IT teams. What are practical ways for small businesses to contain and control data breaches? That's a really good point, and I've certainly sort of focused on larger businesses today. In terms of the data breach response plan we went through, that is suitable for all sizes of businesses. That is how you need to determine whether or not there's been a data breach. And even that sort of diagram, that chart I went through, the different phases that you need to think about in terms of preparation and then monitoring for any sorts of issues. I would also say that if you've got we outsource IT managed services, yeah. So if you outsource your IT managed services, then you want to make sure that the team you've outsourced to can help in these situations, and that you want to have a think about the services they're providing, whether or not that is sufficient for you. We did just touch on the small business exemption. I'm not sure if that applies to you, but it may well. But of course, there is definitely a business case for wanting to ensure that no cybersecurity incidents occur. The next question that's come to, what are the requirements in respect of content delivery and frequency of SAT training? Where can we locate these details? I am not sure what SAT is in that context, but with respect to any sorts of training, there isn't a specific guideline. I would say that sort of once a year is adequate, but you probably want to foster that culture, remind people regularly if people receive scam emails, security awareness training. Thank you. Yeah, I think once a year is probably adequate, but I think in terms of that ongoing culture, for example, if we were to receive a scam email, you'd probably share it amongst the team and say, look out for this, everyone. And then I also have a question here of any pointers for government agencies. I think with respect to government agencies, obviously it's super important, much like any business really, to look after your cyber safety, because the types of information you have is probably quite confidential. Certainly under relevant laws, what is different there for agencies is that you should have privacy. You must have a privacy impact assessment in place anytime you're doing any sort of new project with what you're doing, or you're launching anything new. And so you should be definitely in that preparation phase using a privacy impact assessment. I am curious if there's any more questions. I think that might be all of them. What I might do then is I might wrap up. Thank you so much for attending today. As I said, there is a couple of slides here. We're going to send them all through to you. If you'd like to book in a call with us to chat to our enterprise team, please feel free. We'd love to talk to you. If you've got any additional questions, we'd also love to talk to you. So thank you so much for joining us.